colonization is profoundly paradoxical, but at the same time, it also reveals that the respondent is indeed aware of the lack of legal basis for its claims. Furthermore, and as it appears from the 2023 judgment rejecting the objections based on monetary gold principles raised by Venezuela, colonial powers accepted through the Geneva Agreement that its conduct at the time could serve as a basis for the claim of nullity. Thus, far from putting Venezuela at a disadvantage, the Geneva Agreement, in fact, offered it the possibility to reopen the case of Guyana Essequiba, to quote the words of the Venezuelan president, Raul Leoni, at the time of its conclusion. The Geneva Agreement would become an instrument of decolonization, turning against decolonized Guyana if it had allowed its neighbor to maintain an exorbitant and unfounded claim indefinitely, hanging a sword of Damocles over nearly 3/4 of the territory inherited upon accession of independence. Mr. President, members of the court, the fourth chapter of the rejoinder presents the Geneva Agreement as an instrument of novation, as a novation, a mutually agreed substitution of the previous situation based on colonial domination for a new negotiated framework. According to Venezuela, concluding the Geneva Agreement, Venezuela, the UK, and the future state of Guyana agreed to a novatory process that precluded any later reliance on the null and void 1899 arbitral award. Under a new scholarly guise, drawing roots from Roman law and backed by decolonization law, the argument of novation resembles the one rejected by the court in 2020, but reiterated stubbornly in the rejoinder, and is based on the agreement that the Geneva Agreement settled the question of validity of the award once and for all. The argument of novation differs, however, by arguing that the Geneva Agreement would have fully replaced the former legal regime established by the award, and it necessarily presupposes that this regime had established obligations. Indeed, as Venezuela states, transformation constitutes the replacement of one set of obligations with another. The novation is thus the replacement of valid existing obligations with a set of other obligations. However, since Venezuela maintains that the sentence is invalid, its argument of novation is flawed. In fact, this argument presupposes what the respondent rejects. If the sentence is null and void, it cannot give rise to obligations, and if there are no obligations, there is no question of replacing them entirely with a new mandatory regime contained in the Geneva Agreement. The Venezuelan argument of novation, therefore, is afflicted by an insurmountable internal contradiction. If it was serious, the departure point of any argument of novation should accept that the award is valid and does create obligations, because in order to use the Permanent Court of International Justice's words, it is in the nature of a declaratory judgment, the intention of which is to ensure recognition of a situation at law once and for all, and with binding force as between the parties, so that the legal position thus established cannot again be called in question insofar as the legal effects ensuing therefrom are concerned. On that basis, Venezuela would have to demonstrate that the Geneva Agreement contains consent, unequivocal and unambiguous consent to effect a novation, that is to say, replace a situation, a legal situation established by the award and which is binding by another binding situation governing the same subject matter. But the Geneva Agreement had no such legal effect whatsoever. The effect of the Geneva Agreement is not to have recognized the nullity of the award, nor to have settled the matter, nor to have by itself replaced the obligations of the award by another legal regime, since it did not establish a new boundary. The sole effect of the Geneva Agreement was to allow a discussion on the subject of the validity of the award and to have instituted a mechanism for this discussion to lead to a definitive settlement of the dispute arising from Venezuela's claim of nullity, resulting either in the confirmation of the validity of the award and thus the established legal situation through it, or on the declaration of the nullity of the award and therefore a new demarcation of the border between Guyana and Venezuela if the 1905 treaty and the frontier that it agreed were also and distinctly affected by it. In short, the Geneva Agreement cannot reasonably be interpreted as effecting an innovation in whatever form. Mr. President, members of the court, to conclude, I would say that there is no doubt that the first part of Venezuela's rejoinder seeks to challenge your 2020 and 2023 judgments. The respondent, in fact, makes no secret about this, as it rejects them. However, it never directly challenges the principle of res judicata, and it has not filed an application for a review under Article 61 of the statute, which is the only procedure allowing the principle of res judicata to be challenged. It must be concluded, therefore, that Venezuela has not discovered any new fact of such a nature had it been known as to be a decisive factor on the conclusions reached by the court in its judgments of 2020 and 2023. And in these conditions, these judgments remain res judicata for the parties in the court itself. In the 2020 judgment, by referring to its jurisprudence, the court emphasized that a judgment on jurisdiction as on the merits is final and binding of the parties under Article 59 and 60 of the state statute. Consequently, depriving a litigant of the benefit of a judgment it has already obtained must in general be seen as a breach of the principles governing the legal settlement of disputes. In this case, all the arguments presented in the rejoinder are on points that have already been explicitly settled, either through or through logical implication, and therefore fall under the res judicata effect. The standard utilized by the court to examine a question of jurisdiction at the merits stage is not whether to find if the arguments presented are new or if they recycle previously stated arguments, but if the decision on them would not contradict the finding of jurisdiction made in the earlier judgment. However, it is undeniable that if these contentions were retained, the contentions of the respondent in the reply would, therefore, if upheld, effectively reverse the 2020-2023 judgments. Guyana, therefore, respectfully requests the court not to deprive it of the benefits of those judgments and to proceed with the settlement of the dispute on the validity of the 1899 award. I would like to thank the court for its kind attention, and I would like to request the President to give the floor to Madam Ambassador Ms. Tonnet Street to address the subject of the geographical context of the dispute. Thank you very much.
Je remercie le professeur Darjon. I now give the floor to Ambassador Tonnet Street. You have the floor, madam.
Thank you. Mr. President, members of the court, it is my privilege to address the court on the nature of the territory that lies at the very heart of this case, the Essequibo. Before the court turns to the legal questions surrounding the 1899 arbitral award and its validity, Guyana considers it appropriate to set out concretely what is at stake in these proceedings. As the court will see, Venezuela's claim is not directed at some remote frontier land. It is directed at the heart of my country, the vast majority of its sovereign territory, over 70% of it. Let me begin with the sheer scale of what is being claimed. Guyana is the third smallest country by geographic area in South America, comprising no more than 215,000 square kilometers of land. Venezuela, by contrast, is more than 4 times larger. The area claimed by Venezuela comprises all of Guyana's land territory lying to the west of the Essequibo River, after which the region is named. It accounts for almost 3/4 of Guyana's total land territory, a vast expanse of about 159,500 square kilometers. 6 of Guyana's 10 administrative regions are located within it. I respectfully ask the court to pause on this figure. Venezuela is claiming almost 3/4 of Guyana's sovereign territory, the land in which much of Guyana's population lives, where much of its economic activity takes place, and where its most precious natural, ecological, and cultural treasures are found. For a small developing nation, the loss of nearly 3/4 of its territory would not be a border adjustment. It would be the dismemberment, indeed, the effective destruction of the country. I turn now from the size to the character of the territory Venezuela claims, because its significance to Guyana is not only a matter of size, it is a matter of what the land contains and what it means to our Guyanese people. Guyana's name is aptly derived from an Amerindian word, Guyana, meaning the land of many waters. That is because Guyana possesses a vast hydrographic network consisting of 14 major drainage basins. The Essequibo River is by far the longest, extending some 1,014 kilometers, making it one of the largest rivers in South America. Its major tributaries, the Potaro, the Cuyuni, the Mazaruni, and the Rupununi, all flow through the Essequibo region. These rivers are the arteries of our national life. For the people who live in the Essequibo, they are how communities stay connected and communicate and trade with one another. They are the source of fresh water and the lifeblood of ecosystems that support biodiversity and vital carbon sinks for current and future generations. The natural endowment of the Essequibo region includes more than its rivers. The region is also lined by interconnected mountain ranges, including the Pacaraima Mountains. This is where Guyana's highest mountain, Mount Roraima, forms a tripartite boundary among Guyana, Venezuela, and Brazil. In the very center of the Essequibo region lies the Irocrama rainforest, the green heart of Guyana, one of the last 4 untouched tropical rainforests in the world and a site of global ecological significance. This pristine and delicate environment encompasses a vast area that is universally recognized as rich in diverse species of plants, animals, and insects, including many threatened with extinction. It is a sanctuary for conservation, scientific research, and ecotourism. Guyana has designated 371,000 hectares of pristine forest at Irocrama to promote the conservation and the sustainable and equitable use of tropical rainforests. The ecological significance of the Essequibo region is matched by its economic importance. The region is the engine of our economic development. Gold mining in parts of the region dates back to the 19th century. Considerable deposits of bauxite and manganese are also found in the Essequibo region. There is significant potential for the exploitation of oil and natural gas in the waters adjacent to its coast. These natural endowments are essential to Guyana's economic development. The region also supports substantial agricultural activity, from rice cultivation along the low-lying coastal areas to cattle ranching in the upper Essequibo area, which supplies beef for export. I have described our land. Let me now speak of the people, because the Essequibo is not merely territory. It includes the people who inhabit it, who administer it, and who belong to it, including my own family. According to the most recent census conducted in 2022, the Essequibo region has a population of 313,175, more than 1/3 of Guyana's entire population. These include members of 9 indigenous groups, the first inhabitants of this land. The remainder of the population reflects Guyana's rich ethnic and racial diversity, including descendants of Dutch settlers, the first Europeans to occupy the territory, and descendants of Africans and Asians brought to this land as slaves and indentured servants respectively by Dutch and later British colonizers between the 17th and 19th centuries. As Guyana's agent, Mr. Greenidge, will shortly explain, it is a historical fact that there was no Spanish colonization or permanent settlement anywhere in this territory. The Spanish may have been the first Europeans to set their eyes on the vast northern coast of South America or to claim it, but they never established a presence of any significance there, nor have they ever administered it. As Mr. Greenidge will explain, the British followed the Dutch into the Essequibo region during the first half of the 19th century, forged alliances with the various indigenous communities, explored and mapped the area, and expanded British settlement and administration beyond the coast into the interior. There was never any Spanish or Venezuelan administration there. British administration deepened in the second half of the 19th century and continued until Guyana's independence in May 1966. Since then, Guyana has exercised full sovereignty and governance over the Essequibo region. It administers education through schools across the region. It operates postal services, manages fisheries, enforces environmental regulations, and invests in infrastructure projects. It collects taxes through the Guyana Revenue Authority. Guyana also conducts national and regional elections in the Essequibo region, as it does everywhere in Guyana. In the last elections held on September 1, 2025, 9 members of parliament were elected from geographical constituencies in the Essequibo. These are not abstractions. In exercising their democratic right to vote and choosing their representatives, the people of the Essequibo affirm their commitment to and identification with the sovereign state of Guyana. Mr. President, members of the court, I have sought to show in concrete human and physical terms what the Essequibo region is. It is an integral and essential part of Guyana. Its geography, its economic activity, its culture, and the continuous governance of its land and peoples, first by the Dutch and then by the British, and since 1966 by Guyana itself, are not matters of abstract historical interest. They are the substance of Guyana's national life. They are an indelible feature of Guyana's national and cultural identity, and they are the crucial foundation for Guyana's security and development. Guyana has no designs on anyone else's territory, but we insist on our rights to our own territory, which, by virtue of the arbitral award of 3rd October 1899, includes Essequibo. Guyana's legal team will explain why that award remains legally valid and binding on both Venezuela and Guyana, and why Venezuela's challenges to it should be rejected. I am very grateful for the court's attention, and I ask that you invite Mr. Carl Greenwich to the podium to make Guyana's next presentation. Thank you.
I thank Ambassador Street. I now invite the agent of Guyana, Honorable Carl Greenwich, to address the court. Sir, you have the floor.
Mr. President, members of the court, it is my great privilege to address you this morning, and I will continue Guyana's presentation on the territory in dispute. Ms. Street discussed the land and its people. I will now briefly describe its history as part of a Dutch and then a British colony in the period leading up to the boundary dispute with Venezuela that began in the middle of the 19th century. Mr. Reichler will then carry the story forward through efforts by Great Britain and Venezuela to resolve this dispute with the support of the United States, culminating in 1897 with the execution and ratification of the Treaty of Washington, which enshrined the agreement to submit the dispute to arbitration. The post-Columbian history of our territory begins with the arrival of the Dutch in 1598. They were the first Europeans to establish themselves in what is now Guyana. By 1616, they had founded the colony of Essequibo, erected Fort Kaikoverall along the Mazaruni River, west of the Essequibo, as their seat of government, and begun to settle and administer the territory stretching westward toward the Orinoco. 5 years later, in 1621, the States General granted the Dutch West India Company its charter, by which it took charge of running the colony. In 1744, the seat of Dutch administration was moved to Fort Zeelandia. And the Spanish? They were nowhere to be found, not east of the Orinoco at any rate. Their nearest outpost was San Tome on the banks of the Orinoco. This was the easternmost Spanish settlement. The Spanish governor there was candid about his predicament. The settlement, he wrote, was so far distant from other Spanish possessions, the nearest being Venezuela, more than 650 kilometers away. Later, a settlement at Upata, slightly south of San Tome, was established. Spain never settled any territory farther east of the Orinoco. Spanish attempts to do so were repelled by the Dutch. The reality was enshrined by the Treaty of Munster in 1648. Spain recognized Dutch independence and expressly accepted the territorial status quo on the South American mainland. In 1730, the Treaty of Utrecht reinforced that of 1648, confirming Dutch authority over the territory and settlements it had established in its South American colonies, which then included territory west of the Essequibo River. Over the course of the 18th century, the Dutch moved deeper into the interior of the Essequibo region and further westward along the Atlantic coast. This map, produced in 1748, shows the extent of Dutch settlement and administration of the Essequibo River at that time. The Dutch were then settled along the Pomeroon River, which still bears its original name, as well as Cape Nassau, Moruga, Spruit, Weimar, and Amakura at the mouth of the Orinoco River. The extensive Dutch settlement of this territory during the 17th and 18th centuries is evidenced by the Dutch names maintained to the present day of the villages, towns, rivers, and other geographic features. 35 of these place names are now listed on your screens at tab 4 of your folders, along with their geographical coordinates. In sharp contrast to the widespread Dutch settlement of the territory, lying between the Essequibo and Orinoco rivers, there were no Spanish settlements east of the Orinoco. Venezuela recognizes Dutch presence on the west bank of the Essequibo, but seeks to characterize this as very limited and temporary in nature. That is historically inaccurate and not supported by the evidence. What Venezuela does not say, and what it cannot say, is that there was any Spanish settlement or administration in this territory. By the early 19th century, the Dutch were displaced, but neither by Spain nor by Venezuela. They were displaced by Great Britain. After tensions arose between the two powers, in part because of the Dutch had backed the American colonies in their struggle for independence, Britain seized the Dutch possessions in this area, and in the early 1800s. In 1803, the Netherlands ceded its colonies to Britain under the Articles of Capitulation of Demerara and Essequibo. At the close of the Napoleonic Wars, the Dutch formalized the transfer. The 1814 Convention of London ceded the colonies of Essequibo, Demerara, and Berbice to Britain. The Treaty of Paris of 1850 confirmed it. Only in Suriname in the east was returned to the Dutch. For the first decade and a half after the Treaty of Paris, Britain maintained the separation of Berbice and the Essequibo Demerara. In 1831, King William IV merged them into one to form the colony of Great Britain. The colony of British Guyana. With a newly consolidated colony, Britain set about increasing its understanding of what it possessed. It began by commissioning a survey of the territory, which included an effort to determine its western boundary, that is, where British Guyana ended and the nascent Republic of Venezuela began. Robert Schomburgk was entrusted with this task. Schomburgk, a German-born botanist, surveyor, and geographer of considerable distinction. Between 1835 and 1839, Schomburgk carried out 3 major expeditions into the territory west of the Essequibo under the auspices of the Royal Geographical Society. In the process, he traversed vast swathes of the interior. Venezuela's rejoinder dismisses Schomburgk as a mere Russian-Prussian technician who drew boundary lines, different from the one that had been known until then. In fact, until then, there was no known boundary, much less one that was recognized or agreed. The Schomburgk expedition was an effort to establish such a boundary. In 1840, following his earlier excursions through the territory west of the Essequibo River, Great Britain directly commissioned Schomburgk to map out the colony's borders. The intention had been to share the results with Brazil and Venezuela and to inform Venezuela in advance of Schomburgk's mission and its objectives. The Venezuelan president, José Antonio Páez, did not protest. In fact, he welcomed Schomburgk's mission. British colonial records report that President Páez conceived this to be the best opportunity to settle definitively this affair, which interests both nations. He also proposed that the two countries set up a joint commission to conduct the survey. prefatory to concluding a treaty of limits. But by the time the Venezuelan president's message reached London, Schomburg had already set out on his mission. Between 1841 and 1844, Schomburg conducted 5 expeditions into the interior, shown on this map. In the first trip, shown on the map as Trip 1, he journeyed along the Berima and Cuyuni rivers and raised British flags and markers at Berima Point on the coast. In his own words, the British Empire acquired, therefore, Guyana, with the same claims to the termini of its boundaries as held by the Dutch before it was ceded by treaty to Great Britain. Of equal importance is the determination of the western boundary of British Guyana, the limits of which have never been completely settled. In this report, Schomburg documented the chain of Dutch settlements stretching westward to the Berima River and noted that disinterested scholars in the 18th century had uniformly treated the Berima River as the western edge of Dutch territory. He placed the British frontier at the Amakura River, 4 miles west of Berima Point, as is no doubt the most natural limit west of the possessions of the Dutch. The map and boundary line he produced became what is known as the Schomburg Line. It became the basis of British territorial claims in the late 19th century, including that of the arbitration against Venezuela that resulted in the award of the 3rd of October 1899. The Schomburg Line that the British presented to the arbitral tribunal is shown here, highlighted in yellow. The actual British claim line in the arbitration is highlighted in green. Venezuela's reaction. The Schomburg Line triggered consternation in Venezuela, which protested it and asserted its own claim to the territory east of the Orinoco River, extending to the Essequibo River as shown here, highlighted in red. In asserting this claim, Venezuela did not point to any military bases or to settlements it had built, officials it had posted, or taxes it had collected. It pointed to the heavens, quite literally. Venezuela invoked the papal bull of 1493, issued by Pope Alexander VI, a Spaniard, and declared on that basis that the right of Spain to the territory of America has always been indisputable in the eyes of all nations of the world. The treaties by which Britain inherited the Dutch colonies were, in Venezuela's view, void because the Netherlands had conveyed to England what did not belong to her and what she knew did not belong to her. End of quote. Great Britain rejected Venezuela's claim and continued to promote settlement of the region under its administration within the area encompassed by the Schomburg Line. The British made efforts to reach an understanding with Venezuela on the location of the boundary. Various proposals were exchanged, beginning in the 1840s, but no agreement was reached. In the meantime, British settlement continued to expand westward within the Schomburg Line. Venezuela felt powerless to stop it and grew increasingly desperate in attempting to prevent further British consolidation. Some progress towards a resolution was made in 1850 when Britain and Venezuela exchanged letters in which each undertook not to encroach further on any disputed territory until a final settlement on the boundary was reached. There was a problem with the so-called 1850 agreement, however. It did not define or describe the territory that was disputed, leaving this for each party to determine for itself. Over the course of the following decades, Venezuela repeatedly complained about what it considered Britain's frequent violations of the 1850 agreement, including its extension of control over the disputed territory between the Essequibo and Orinoco rivers. In 1877, Venezuela's minister in London, Jose Rojas, approached the British Foreign Office with a proposal for an amicable settlement. By 1880, formal negotiations had begun, but no progress was made. In November of 1883, with the prospect of a diplomatic settlement bleak, Venezuela proposed for the first time that the territorial dispute be settled by arbitration, pursuant to which the decision of an arbitrator who freely and unanimously chosen by the two governments would judge and pronounce a sentence of a definite character. Great Britain rejected Venezuela's proposal for arbitration. Undoubtedly, it offered to arbitrate only the territory west of the Schomburg line, that is on Venezuela's side of the line. This was quite understandably not acceptable to Venezuela. Faced with British intransigence on the scope of the arbitration, on the 20th of February 1887, Venezuela broke off diplomatic relations with Great Britain. In its exasperation with the British, Venezuela turned to the United States for support and assistance, asking the US to use its power and influence to persuade the British to submit to arbitration title to the entire territory claimed by both Britain and Venezuela, that is, all the land lying between Essequibo and the Orinoco rivers. The history is clear and established by the evidence before the court. It was Venezuela that insisted on arbitration. It was Venezuela that brought the United States into the picture to help it obtain the arbitration agreement with Great Britain that it was unable to obtain on its own. And ultimately, as Mr. Reichel will show you, with the support of the United States, Venezuela secured the arbitration agreement on which it had been insisting for more than a decade in the form of the 1897 Treaty of Washington. Right up to the president, Venezuela heralded and celebrated the treaty as the accomplishment of its long-sought objective and profusely expressed gratitude to the United States for its indispensable contribution to that end. Venezuela maintained this attitude towards the treaty and its implementation for the next 60 years. It neither questioned, challenged, nor criticized the treaty. In contrast, in these proceedings, Venezuela takes exactly the opposite position. It attacks the very treaty, claiming now that it was unlawful and invalid on several grounds. At this point, I pass the baton to Mr. Reichler and invite you to call him to any of Venezuela's belated. Mr. President, members of the court, I thank you for your kind attention, and I ask that you invite Mr. Reichler to the podium, perhaps after a short break.
I thank the agent for his presentation. Before I give the floor to the next speaker, the court will observe a break. The hearing is a break of 10 minutes. The hearing is suspended.
not to say.
What?
Do not say what you ought not to say.
That the present administration has repeated the old cycle of doing what the imperial master did, keeping the majority of people in the place, identifying a few folks, and you know who they are. Give them ministerial positions and other positions, so you tell the world we have a mixed governance. But we know there are just 3 or 4 people who determine how the money is collected and how it is spent. And this is an old imperial trick beginning from what happened in West Africa and parts of India. The answer is we've got to educate our young people, irrespective of race, color, or creed, as the danger they face and the potential they have if they stand up like men. I listened to the Cuban ambassador, who made a fantastic statement at this hotel in Charlotte Street a few Sundays ago. And I was appalled that our president can repeat the same language that his new bosses are using about democracy in Cuba. What is democracy? When one man or a cabal make all the decisions as we see here and elsewhere, ignoring the fact that the Cubans have given unbelievable help to our people in this country, trained doctors, engineers, sacrificing their own people. And we have a government who are preaching about Cuba must go for democracy. What is democracy? By their term, the demons gone crazy. But I'm repeating myself. Unless we teach our young people in primary schools, secondary schools, and in our university, the history of this country, to give them the strength to face a new form of being recolonized, we are in serious trouble. Where the big bucks are not going our way. Where we have projects cost billions of dollars and we can't see results. Where I live, for the week, we had blackouts, but yet you have 2 Turkish ships and all this billion spent. You know why? Money is not a problem. It is management. And so long as you pick management, not based on competence nor experience, but on who are friends and who can split the dollar, we have this situation continuing into the next generation.
Mr. Green, to this end, what message would you have for Guyanese? even as we are celebrating independence in some levels of uncertainty, what assuring message would you give to Guyanese in closing?
My message is to let parents, adults and elders pass on to their children the struggle for independence, and don't take it for granted, and to prepare an educational package within the communities, within the schools, within the households, to say to our young people, we've got to protect and preserve that independence, which we got 6 years ago. And that independence must go beyond the flag, an anthem, and a few slogans. It must mean harmonizing and mobilizing our God-given resources for the benefit of our people. Is our people, in particular, the African slaves who civilized the entire coastal belt by digging thousands of miles of canals and dams. Walter Rodney's book, How Europe Underdeveloped Africa, is a good example of what I'm talking about. That we must respect and remember the sacrifice of our ancestors, the Indians who came here, practice deferred gratification so they can climb the ladder. We must not surrender that to clever form of being recolonized. And that's what was happening as we celebrate 6 years of independence. I have no doubt that you hear all kinds of statements from the ruling cabal, ignoring the fundamentals that we are not benefiting from the grace that God has given us. I have a theory that if we don't make use of our blessings, it will become a curse. Good weather, plenty of resources, and say to the government, we don't want you being ubiquitous, controlling everything. And that's what we're hearing. Let the Constitution work. Let the concept of local government be real. Let the institutions and the commissions function as they were intended to function. Our young people, therefore, must be bold and not, look, when I attended the thing to honor the Cubans, I spoke to many young people in and out of the public sector. And the recurring statement, they were afraid to show their faces at the square of the revolution and at the bar in Charlotte Street. They were afraid for fear of being victimized in one way or the other. We must eradicate that fear, because fear in these days is our worst enemy. The message is, our young people, be fearless without breaking the law. Speak up, write, And even among the PP supporters, the majority were not getting the benefit from our bounty. It's going to the hands of a few cabal. Speak up. Look at the figures. I read Cartoon over the past few days. The figures are frightening. Another 200 odd million US for this gas to show project. As they said, we now become the milking cow. Young people of Guyana, stand up. Stand up for your rights. Don't be afraid. Speak up. Your ancestors, whether they were slaves, Aborigines, or indentured laborers, worked hard to build this country.
All right, Mr. Green, thank you so much, and it's always a pleasure.
Please be seated.
The sitting is open. Before we start our judicial proceedings today, I would first like to pay solemn tribute to the memory of Judge
Stephen Schweber, our esteemed former colleague, who sadly passed away on the 9th of April. The late Judge Schweber was a member of the court from 1981 until 2000, and he was elected by his peers as vice president from 1994 to 1996, and as president from 1997 to 2000. Born in 1929 in New York, Judge Schweber received a BA with highest honors in government from Harvard University, and then chose to focus his studies on international law, first at Cambridge University, and then at Yale Law School, where he received an LLB. During his long and illustrious professional life, Judge Schweber combined legal careers as a practitioner, an academic, a legal advisor to his government, a judge, and arbitrator. In 1959, he was appointed assistant professor at Harvard Law School, where he founded
what later became the CashApp competition, where hundreds of universities around the planet participate every year. He then became the Bering Professor of International Law at Johns Hopkins School of Advanced International Studies. In the 1960s and 70s, he served as the US
State Department in various capacities, including as assistant legal advisor and deputy legal advisor. In parallel, from 1977 to 1981, he was a member of the International Law Commission. Judge Schweber thus arrived at the Peace Palace in 1981 with a wealth of valuable experience, which he translated into a rigorous intellectual approach to the court's judicial deliberations without ever overlooking the importance of maintaining a grounded appreciation
of the practical effects of the court's rulings. By his own account, he had followed the creation and development of the United Nations with great enthusiasm and thus relished the opportunity to put himself at the service of the principal judicial organ of the United Nations. During his 2 mandates, Judge Schwebel was extremely active in the judicial work of the court, in particular overseeing plenary meetings and drafting committee sessions in his capacity as president. As a judge, he was involved in the adjudication of 38 cases, covering a range of complex and often profoundly far-reaching questions of international law. While he fervently believed that the strengths of the court lay in the collective nature of its deliberations, Judge Schwebel nonetheless remained a fiercely independent thinker. It was not uncommon for him to dissent from the majority view, and his persuasively crafted opinions and declarations continue to provide much food for thought for students, scholars, and practitioners. Judge Schwebel left an indelible mark in terms of the general administration of the court, thanks to various significant innovations he launched to improve the working conditions.
At that time, and in subsequent presentations to the United Nations, Venezuela made clear that although it had changed its position on the award of 1899, it continued to regard the 1897 treaty as a valid treaty. It was not until 1963, 66 years after it ratified the treaty, that Venezuela first began to find fault with it. My presentation on the treaty will be in 4 parts. In the first part, I will set out the issues in this case on which both Venezuela and Guyana agree, or at least which they do not dispute. In parts 2 to 4, I will address the 3 specific challenges Venezuela has made to the treaty's validity, all of which Guyana considers groundless. I turn to part 1. As a general matter, the parties do not dispute the circumstances that led up to the 1897 treaty. In particular, they agree that the dispute over the boundary between Venezuela and British Guyana began to heat up in the 1840s, and that between then and the early 1980s, Venezuela and Great Britain exchanged various proposals for delimitation of the boundary, all without success. Both states claimed the entire territory between the Essequibo River in the east and the Orinoco River in the west. Their respective proposals and counterproposals failed to resolve or even substantially narrow this dispute. Throughout this 40-year period, Venezuela complained about what it considered the westward expansion of British settlement in the territory between the 2 rivers. Although, as you have heard, an agreement was reached in 1850 not to expand further into what they both referred to as disputed territory, Venezuela complained that British expansion continued. Recognizing that it was unable to stop the British diplomatically or militarily, Venezuela implored them to settle the dispute by arbitration, but the British refused. As Venezuela acknowledged in its counter-memorial, quote, it had repeatedly proposed to Great Britain to settle the territorial dispute by arbitration, but Great Britain had systematically refused such solution, end of quote. It is also undisputed that between 1883 and 1895, in the face of what it claimed to be ongoing British settlement in the disputed territory, Venezuela turned to the United States for support, specifically requesting US intervention with the British to obtain their agreement to settle the dispute by arbitration. To this end, this is what Venezuela's foreign minister wrote to the US Secretary of State in 1883. To carry this controversy to a practical ground and possible termination, there is, in the opinion of the President of Venezuela, only one, and at the same time, very simple way, arbitration. And for arbitration, there is only one government who could propose it with real effect and decide the question of boundaries to the satisfaction of Venezuela, the United States of America. It is also agreed that the United States responded sympathetically to Venezuela's entreaties, that it remonstrated with the British over the alleged westward expansion of British Guyana, and that it insisted on arbitration of the territorial dispute. No less a figure than the President of the United States, Grover Cleveland, championed Venezuela's cause. In September 1988, Venezuela's mission in Washington wrote this: "To the President of the United States, Grover Cleveland, my country is largely indebted for his sympathy and the notion taken by him toward the government of Great Britain in showing that government that the United States was not indifferent to the unwarranted acts of encroachment by Great Britain on the territory of the Republic of Venezuela. The timely interference on the part of President Cleveland has, for the present, stopped the English government in her attempted acts of spoliation, encroachment, and appropriation to herself of very nearly 1/3 of our whole republic. My government and people feel that in President Cleveland, they have a friend and protector." Despite the efforts of President Cleveland and his administration, the British remained opposed to arbitration with Venezuela, leading Venezuela to break diplomatic relations. In December 1894, with the territorial dispute continuing to fester, Venezuela's minister in Washington, Jose Andrade, a name you will hear frequently in this presentation, wrote to the US Secretary of State, citing the threat of further British expansion and urging the United States once again to intervene on Venezuela's behalf. As Your Excellency will understand, the dispute already has a phase that we would call threatening, given that the colonial authorities are preparing to expand their jurisdiction even further, and to thus enter into regions where the Republic has established regular centers. In view of this, my government reiterates to the United States government its request for effective and direct intervention, which our minister plenipotentiary presented to the Department of State in Washington some time ago and has continually ratified. Within days, President Cleveland responded in an address to the US Congress. I shall renew the efforts heretofore made to bring about a restoration of diplomatic relations between the disputants and to induce a reference to arbitration, a resort to which Great Britain so conspicuously favors in principle and respects in practice, and which is earnestly sought by her weaker adversary. When the British continued to resist President Cleveland's demand for arbitration, the US applied greater pressure. In July 1895, the new US Secretary of State, Richard Olney, another name that features prominently in the narrative, instructed the US mission in London to convey the following admonition to the British authorities. The duty of the President appears to him unmistakable and imperative Great Britain's assertion of title to the disputed territory, combined with her refusal to have that title investigated, being a substantial appropriation of the territory to her own use, not to protest and give warning that the transaction will be regarded as injurious to the people of the United States, as well as oppressive in itself, would be to ignore an established policy with which the honor and welfare of this country are closely identified. When the British ignored this warning, President Cleveland took matters into his own hands. In his December 1895 address to the US Congress, he expressly invoked the Monroe Doctrine against the expansion of British Guyana, warning the British that, quote, its enforcement is important to our peace and safety as a nation and is essential to the integrity of our free institutions and the tranquil maintenance of our distinctive form of government. Sentiments in the United States, including at its highest levels of government, ran so strongly in favor of Venezuela and against Great Britain that, as Venezuela's foreign minister told the UN General Assembly in 1962, quote, the United States was on the verge of going to war with Great Britain. In this extremely grave situation, that's how Venezuela described it, President Cleveland, with the full support of the US Congress, went beyond words to concrete action. He announced the creation of a new presidential commission of experts, headed by a US Supreme Court Justice, David Brewer, to investigate and report on the true boundary between Venezuela and British Guyana, which the US would then seek to enforce. As President Cleveland explained, when such report is made and accepted, it will, in my opinion, be the duty of the United States to resist by every means in its power, as willful aggression upon its rights and interests, the appropriation by Great Britain of any lands or the exercise of governmental jurisdiction over any territory, after which investigation we have determined a right belongs to Venezuela. This measure, with its implicit suggestion of military intervention by the US, finally broke Britain's resistance to arbitration of the dispute. In its written pleadings, Venezuela acknowledges this. If the British finally accepted to enter into an arbitration process, it was under US pressure, and to ward off the risk of seeing the work of the Venezuela Boundary Commission concluding, as it had to, that the true boundary had always been the one claimed by Venezuela. As Venezuela further acknowledged in its counter memorial, it is a fact that Venezuela requested the protection of the United States in order to resist Great Britain's conduct and reach a peaceful solution to the territorial dispute. It was clear that the possibility of submitting the dispute to arbitration could have materialized only with the support of the United States. And Venezuela continued. Great Britain accepted arbitration only because of the pressure put on it by the United States. Neither this conclusion nor the antecedent events that led up to it can legitimately be disputed by Venezuela at this stage of the proceedings, nor can the fundamental features of the ensuing negotiations that led to the 1897 treaty. In particular, it is beyond dispute that the negotiations were conducted until the final stage directly between US Secretary of State Richard Olney and the British ambassador in Washington, Lord Julian Pauncefote. It is uncontested that Venezuela appointed a team of 2 representatives, Jose Andrade, its minister in Washington, and James Storrow, an American attorney who had represented Venezuela before President Cleveland's Boundary Commission, to liaise and engage directly with Secretary Olney and assure that Venezuela's interests were reflected in the treaty negotiations. It is Also undisputed, that the negotiation of the treaty took place between January and November 1896, that a draft agreement was presented to the Venezuelan government in November 1896, that further negotiations took place directly between Venezuela and Great Britain thereafter, and that Venezuela then authorized Mr. Andrade as Minister Plenipotentiary to sign it, which he did in Washington on 2 February 1897. Later that month, on 20 February, the President of Venezuela, General Joaquin Crespo, submitted the treaty to the Venezuelan Congress with a message calling for its ratification. In so doing, the Venezuelan president expressed gratitude to the United States for the part it played in negotiating the treaty. It is eminently just to acknowledge that the great republic endeavored persistently to direct the matter by the most favorable route, and that the outcome achieved represents an effort of intelligence and will worthy of praise and gratitude from those of us who are familiar with the intricate details of this very complicated matter. The treaty was then ratified by the Venezuelan Congress by legislative decree on 17 April 1897. The final page of this decree is at tab 5.1 of your folders. None of these facts, none of them, are or can legitimately be disputed. I turn to part 2 and Venezuela's main challenge to the validity of the 1897 treaty. This is its contention that it was excluded from the treaty negotiations and that the treaty was, in its words, negotiated by the US and Great Britain, quote, behind Venezuela's back, in collusion with one another to further Britain's interests at Venezuela's expense, with the result that, to cite Venezuela's written pleadings, the treaty was, quote, prejudicial to the interests and dignity of Venezuela in respect of crucial issues. Venezuela argues in particular that as a result of this purported British and American conspiracy, its views on 2 issues that it considered most critical, concerning the acquisition of title by prescription and respect for the 1850 agreement between Venezuela and Great Britain, were not taken into account or reflected in the treaty. The argument is that this purported Anglo-American cabal not only prejudiced its interests, but constituted a fraud on Venezuela within the meaning of Article 49 of the Vienna Convention on the Law of Treaties, sufficient to invalidate the treaty. On the same allegations, Venezuela argues that it ratified the 1897 treaty in error, as defined by Article 48 of the Vienna Convention, on the mistaken understanding that the treaty text negotiated on its behalf by the United States had protected its vital interests, only to find out during the arbitration 2 years later that it did not.
One Love. Advertise with us and let's help you promote your next product, project, or event. More than 1 million viewers every month in Guyana and all over the globe. No project too big, no project too small. Delta 9 Media. Let's help your project reach its widest possible audience.